That was great. Thank you.
Hi, everyone. Welcome to the University of Toronto Joint Centre for Bioethics Seminar Series. I'm Andrea Bianchi, and I'll be the moderator for today's session. Our speakers are Jennifer Chandler and Christy Simpson, and their seminar is entitled Ethical and Legal Issues with Respect to a Brain-Based Definition of Death from an Organ Donation Perspective. Before I introduce today's speakers, I'd like to let you know that the seminar is being recorded. This lecture, along with other archived lectures, can be accessed through the Joint Centre for Bioethics website. The format of our seminar is a presentation by our speakers, followed by a facilitated discussion period. We would like to take a moment to acknowledge this land on which the University of Toronto operates. For thousands of years, it has been the traditional land of the Huron-Wendat, the Seneca, and most recently, the Mississaugas of the Credit River. Today, this meeting place is still home to many Indigenous people from across Turtle Island, and we are grateful to have the opportunity to work on this land. We also stand in solidarity with the ongoing protests against racism and systemic discrimination. Now it is my pleasure to introduce today's speakers. Jennifer Chandler is Professor of Law and Bertram Loeb Research Chair at the University of Ottawa. She is the Interim Director of the University's Centre for Health Law, Policy and Ethics, and Chair of the Ethics Committee of the Canadian Society of Transplantation. She also sits on the Trillium Gift of Life Network Bioethics Advisory Group. She teaches medical legal issues and mental health law, and studies issues arising at the intersection of biomedical sciences, technologies, ethics, and the law. Christy Simpson is an associate professor and head of the Department of Bioethics at Dalhousie University. She is also the department's coordinator of the Ethics Collaborations team, which provides ethics support for Nova Scotia Health, the IWK Health Centre, and Nova Scotia Health Ethics Network. Christy is also a bioethics consultant with Canadian Blood Services and has participated in several national forums on organ and tissue donation and transplantation. Christy and Jennifer, I'll turn it over to you.
Great.
Thank you.
Thanks so much, Andrea. Thanks. All right, it's indeed a pleasure, I think, for both of us to be here to present as part of the JCB Seminar Series, and we really appreciate this opportunity to talk about the project that we're both involved with, and specifically from the legal and ethics perspective around the key issues as well. So as you see on the slide here, we're going to be talking a little bit first and setting the stage for you around what is the Death Definition and Determination Project, and that's sort of the short form of the title. But really, if you hear us refer to DDD project, that's actually the same thing. And it is a brain-based focused in terms of the definition of death and determination. And you'll hear a little bit more about that a little bit later on in terms of the why, what, and how of that project itself. Jen will then provide some further legal context and sort of set the stage more broadly. I'll talk a little bit about the ethical context and set the stage more broadly again. And then we're going to both move into talking about some of the specific ethical and legal issues that we're going to address throughout this presentation and sort of end with it there. Looking forward to your comments and questions. Back to you, Jen.
Great. Over to me. And we are going to be tag teaming it back and forth as we go through the project. So to give you a little bit of background on this project, this is a project that's being sort of co-sponsored or organized by the Canadian Critical Care Society, Canadian Blood Services, and the Canadian Medical Association. And the objective, there's two objectives really. One is to come up with a brain-based definition of death, and then to specify criteria for the determination of death. And the distinction here would be, for example, death might be defined as the irreversible cessation of all brain function, whereas criteria for its determination might be the kinds of tests and readings and criteria that would allow one to determine that the definition is satisfied. And so the project has both of those things in its view to try to come up with an agreed consensus definition and then criteria for determination of death. And why this unified brain-based approach? I suppose it reflects the idea that what is central in death is the loss of brain function, and that the alternate existing form of definition based on cardiorespiratory function is death because it entails loss of brain function, would be an underlying sort of implicit element of this project. But sort of more concretely, and why go about the effort of coming up with this brain-based definition of death and the consensus criteria? Well, there's three main reasons. One is that it appears that there's variability both internationally and within countries on the concepts and practices of diagnosing death. And this has legal significance in provinces that define death as to be determined according to accepted medical practice. If you have variability, do you have accepted medical practice? So it is advisable to be clear on what those criteria and definitions are going to be. Another reason is that we've seen in Ontario recently, most recently with the McKitty and Wanunu decisions, but not just those, there have been others across Canada, disputes over the definition and diagnosis of brain death. And so there are questions open that should or could perhaps be, if not entirely resolved, to some extent helped with a bit more focus and clarity on this issue. And then thirdly, we have these continual changes in medical practice that call in, or potentially, I wouldn't say for sure they call into question existing definitions, but they raise questions about existing definitions. And it will be one of our objectives to try to find out if in fact there is a problem with some of these technological changes. And one of them is the use of what's called normothermic regional perfusion in the context of organ donation. And this would be the resumption after cardiorespiratory arrest of circulation, usually with the clamping of arteries to the brain to try to avoid blood flow to the brain, but recirculation within the rest of the body, the cardiorespiratory function. And so if this is being done, what is the significance from a legal perspective of the fact that this cardiorespiratory function has been started if you've determined death based on a cardiorespiratory definition of death? And then all of a sudden we have this form of circulation that has resumed. So this may not be an issue, but it needs to be sorted out about how this fits exactly, coheres with existing legal definitions. So I will turn over to Christy to say a few more words about the organization of the project.
Sure, thanks, Jen. And I think as you get a sense, as Jen's talking through about the sort of origin of this project and the interest in sort of updating, clarifying, becoming more consistent, or developing these consensus-based criteria, there becomes a really interesting question of, well, how do we begin to approach that? Under that rubric of organ donation, and thinking about it most significantly in terms of the dead donor rule, for example, and wanting to be absolutely sure somebody is dead prior to doing organ donation. Obviously, that's of much, much importance. But being sure then about what's our definition and what are our criteria then become really essential as part of this process. And so the way that the project is focusing on moving forward on these aspects is by having these different listed working groups. So there's 3 working groups that are really focused on sort of what's the evidence that's out there that tells us more about what's going on in the brain, what's going on from a circulation or circulatory perspective, that helps us begin to become much more clear about what are we testing and why, and what does that demonstrate to us in relation to that definition of death that's being developed. So there is a group that's looking more at the neurological piece, really looking at the brain and sort of sorting through what do we know about different brain function as it reads on different tests, for example, and what does that mean? There's the circulatory determination of death group that's looking at it from that sense of, and recognizing that there's been a historical perspective on having cardiac or a lack of circulation being that sort of focus of many definitions of death and understanding of it, but also going, well, what's happening when that type of death occurs as it relates to the brain, and how do those things connect together? And so again, looking at what are the criteria, what types of tests, what does the evidence tell us? And in the middle there's sort of the question of ancillary testing. When there might be confounders, when there might be questions about what we're reading in the other types of tests, what are the additional tests that might be appropriate to do? How do they help? And what do they inform as part of understanding, has somebody met the definition of death, right? Has death actually occurred in this context? And so very, as you can see, very focused on particular types of evidence, particular types of questions that relate to clinical practice and are very real, I think, both for families and for the healthcare providers and physicians that are involved in these situations. And that's where the other two groups, I think, become really important as well, which is obviously Jen and I are co-leads for the legal ethics group, and looking at what are those related ethical and legal issues in the context of everything that we've been talking about to date, but also a stakeholder engagement group that wants to think about where's the public on this? What does the public understand about death in the context of organ donation? Where are professionals at, both in the healthcare context, but also more broadly thinking from a legal and ethical perspective, where there are communities as well. And how will that understanding that from that stakeholder engagement perspective facilitate things like knowledge translation? And another way of putting it is, well, what's important for the public to know about how this work is advancing that conversation around definition of death and the criteria that need to be met in order to satisfy that definition. So those are the five different groups that are working together, and we're going to be sharing information between the different groups to really help understand, I think, the implications of anything that's coming out of the variety of groups together. So with that, I'll hand it back to Jennifer to talk more about the legal context.
Thank you, Christy. So my objective in the next two slides is to give a little bit of the legal background, the legal context. Where are we on legal definitions of death? And I wanted to start just by pointing out, actually, maybe I should start with my second bullet point. So the situation is that there are legislated definitions of death, codified, in other words, in statutes, in a couple of provinces, but most of the provinces have no explicit codified or legislated definition of death, including Ontario. So, for example, Ontario doesn't define death precisely in its Vital Statistics Act, where it talks about registering deaths and who fills out certificates of death. It doesn't actually define what death is. And in the legislation, the closest definition we have is in the organ donation specific legislation, which says for the purpose of organ donation, death is to be certified by two doctors in accordance with accepted medical practice. So it is in essence delegated to medical community to determine what death is, define it, as well as to specify what are the criteria going to be to allow us to determine that that definition has been met. What are the tests and what are the levels of readings of various things? So a couple of provinces do have definitions of death that, for example, might say it can be one of two forms: cardiorespiratory, total and irreversible loss of all brain function, or complete and irreversible loss of cardiocirculatory function. So that's the situation where we are in terms of legal definitions. The common law courts from time to time have had to determine when someone's dead. This is important for a variety of reasons, not just for medical decision making, but also for testamentary and dispositions of property, for criminal law and things like that. And so the common law courts appear to have accepted both brain-based definitions as well as cardiorespiratory criteria. And against this backdrop, and sometime in the past against this kind of backdrop, in 1981, the Law Reform Commission of Canada looked at this question: should we actually have a clear legislated definition of death across the country? And they recommended that there should be one. They said it was inferior as an option to leave this to medical consensus, or to leave it to sort of elaboration by the common law courts, depending upon what cases came to which court in which jurisdiction, and said this is important enough that we should have a legislated definition. This would reflect the democratic process of deliberating on what that definition should be, and this is a fairly fundamental thing that should, in theory, be consistent across the whole country. So despite that recommendation, there was no movement toward enacting a legislated definition of death. And it still remains a really interesting question. Is it a good idea? Some people say that if a definition is legislated, it becomes cumbersome. It can't be updated as easily. It's always tricky to, it's legislatively, from a drafting perspective, tricky to get the degree of precision that you want. On the other hand, there are these arguments that, in fact, it would be better, clearer, and more sort of consistent with democratic principles to have a legislated definition. And apart from that, you've got, in a federal country, the questions of, do we do that at the federal level in a federal statute? Do you try to do that in the provinces? It's been suggested that the Federal Interpretation Act would be a good place to put a federally applicable definition of death. So that's a little bit of background on what the laws are in the country. But I wanted to talk also about the kinds of challenges to the concept of brain death, because we might think it's predominantly of the type of disputing the concept. And indeed, that is one of the major forms of dispute, but there's a whole bunch of others that might happen upstream of that or downstream of that. So let me give a quick overview of the kinds of legal disputes. And this is important when thinking about trying to come up with a consensus definition. Can we come up with a definition that avoids some of the complexities or ambiguities that give rise to this form of dispute? That would be the objective, to be clear enough that we minimize the forms of disputes that might come up. So the first, I guess, key type of challenge would be that the diagnosis is wrong. You might have someone say, I don't disagree with the idea that brain death is death. I just don't think it's correctly diagnosed in this case. And this was an argument made in the McKitty versus Hyani case, in addition to the argument that brain death is not death. But this independent argument was that it had been improperly diagnosed. And so that leaves the question of, well, what kinds of tests are required? What forms of ancillary testing should be done to help a family to accept the definition, or for practitioners to be entirely certain that the diagnosis is correct? So that might be one aspect of dispute that this project could help with, is trying to be clear on what are the standards for testing and what are the standards for the use of ancillary tests. So the second type of objection is an objection to the concept of brain death itself, and essentially is the following argument: brain death is not death. So death is not defined by complete and irreversible cessation of all brain function, for example. It instead might require the cessation of cardiac function, would be an argument challenging brain death. And so the way this comes forward in a legal context, however, is to claim that the application of this test constitutes an infringement of basic human rights of one or more types. So this would, the argument would be under the Charter of Rights and Freedoms, or under human rights legislation in the provinces having to do with non-discrimination in the provision of medical services. And the arguments would be either that the imposition of this definition of brain death is an infringement of religious freedom, if there's a religious objection to that form, that idea of death. Another potential argument, however, which was not raised in the cases in Ontario so far, is a disability discrimination type of argument. It might go something like this: that someone who has lost all brain functions, we'll get to that in a moment, whether in fact all brain functions are lost, but someone who's so severely brain damaged as to have lost irreversibly all brain function, perhaps one might say that person is severely disabled and not in fact dead, and that to label this subclass of people with brain injury as dead is discriminatory, since it removes from them rights that others with brain injuries might have, and it's arbitrary to draw the line in this particular location. So those are two forms of human rights-based objection to brain death. The third kind of problem has to do with there being a potential mismatch between the medical tests available and the legal definition of brain death. So if we are to say, well, first let's start with the first objection. If there are no accepted medical criteria, or there's no consistent set of medical criteria being applied, then someone might argue that a diagnosis of death based upon somebody's set of medical criteria is not valid. And so any definition like we have in the Ontario Trillium Gift of Life Act, the organ donation legislation that says death is to be determined according to acceptable medical criteria, that determination of death is invalid because there are no accepted medical criteria, and any diagnosis is therefore legally suspect. That's one form of argument. Another one, distinct but of the same kind of level of challenge, is that the medical tests that we have and use cannot actually establish loss of all brain function. They establish some things. They establish that there's loss of respiratory drive, the apnea test, various reflexes are lost. But this argument is getting at a potential slippage between what those tests tell us and the legal definition, which is irreversible and complete loss of all brain function. Here we also have another particular problem which arises, which is that despite the loss, the definition referring to complete and irreversible loss of all brain function, it appears that some, and here I'll put it in scare quotes, the word functions. I'll say some functions in square quotes appear to persist despite brain death. So various brain hormone secretions, hypothalamic function, osmoregulation, pituitary gland function, continue even after brain death. Now, is that a function? And here we have a problem because the legal terminology is underspecified. We haven't said what a function is. And I think at one extreme, people might agree that the persistence of a couple neurons here and there does not make a function, but is the continuation of osmoregulation a function? And so this is something to be sorted out if we're going to avoid this kind of problem. And then finally, an indirect way of challenging the concept of brain death is, and this has been seen in the United States in a number of cases, that a family who objects to the brain-based definition of death will fight that case at the upstream stage by refusing to consent to brain death testing. So since consent is required for intervention on the body of a living person, if you haven't yet been able to test someone and determine they're brain dead, then consent might appear to be required to do that testing. And so you can see how this sort of short circuits the whole inquiry into whether someone is brain dead or not, and is something that will have to be sorted out. So I will turn back over to Christy at this point to talk about some of the ethical context.
Sure, thanks, Jen. And I think as Jen's been going through this and really setting up the stage so nicely around the legal context, for those of you that come at this from an ethical perspective, you can hear those resonances of, this is where the ethics issues start to fit into about, well, how do we begin to think through some of the issues that might arise in the end-of-life context, in the organ donation context, around, as we're talking about different functions, how does this relate to how people understand what the relationship is with the person who may be dead, right? In terms of, has that changed the sense of relationship? Has that changed the sense of whether the person who has died is still seen as a person, as a patient, in those kinds of ways? And I think it's sort of the fascinating way that we can see how the legal and ethics issues, as we get more precise and get more clarity around some of the legal aspects, there still is this broader sense in which some of the ethical questions are going to take root as well. Because as clear as we might be about a definition of death, it's already in there around, we're not making the broader claim, which is that everyone's going to agree with that definition of death or the criteria by which necessarily that it's going to be demonstrated, even if there's consensus around that from a medical perspective, for example, right? That there can be those kinds of questions. And so in this sense, then, I really want to be clear that from the ethics side, we move into this conversation about thinking about brain death and the types of criteria and the types of tests that are being used, mindful of these are highly emotional contexts sometimes. It's highly emotional conversations with families. It can be difficult for physicians and clinicians to engage in this space as well. And so it's being mindful of both the conversations that go really well and the understanding that death has occurred that may then lead to organ donation, and recognizing that often will happen, and what that means for those families or the family members that are have participated in that process and understand what has happened, but also what happens when there's tension or conflict, what happens about how that is resolved or not, and what happens when that conflict becomes intractable, right, or very difficult to resolve, and then often means moving, as Jen's outlined, into some of the legal cases, right, and needing to move in that direction. So in that context, then we're still thinking about, well, what are the relevant values and principles, and how do they help us characterize, frame, identify, address some of the different issues that arise from that ethical legal kind of lens on what we're talking about in terms of this project. So things like, and the values of respect for persons, what does that fundamentally mean in this context? As much as there's a claim towards a brain-based definition of death, well, what does that mean in the context of respect for equity, diversity, and inclusion? And understanding in a pluralistic community, in a pluralistic country, how do we reconcile some of those tensions at a systems level as well as at the bedside when these conversations arise? So that question of autonomy and informed choices about whether consent is needed becomes very significant, not just from a legal perspective, but from that ethical perspective too, about, I think, for a number of healthcare providers, for physicians that are in this context when disagreements arise, wanting to feel that they've met their professional responsibilities, have maintained that sense of integrity, but also very much wanting to deliver patient and family-centered care and needing to look to how do we trace out some of the issues that arise and see what's going on from a justice or a fairness perspective, what's fair as we wrestle with what is or is not done within a publicly funded healthcare system, for example. How do we think about maintaining trust in the organ donation process in light of disagreements, in light of challenges too, the criteria and definition that could be anticipated and have already happened historically? And where does transparency fit in terms of some of the outputs of this project? That knowledge translation piece that the stakeholder group was going to be looking at will become so critical as well, about how do we talk about this? How do we encourage those conversations writ large, but also in these particular contexts where we're thinking about organ donation and whether death has occurred in this kind of way? So I think between both of our sets of slides around the context, you'll start to see where we're, out of all of the interesting, challenging types of questions that we could be looking at, we're narrowing in on some big sort of buckets, if you will, or particular types of questions and issues that we're going to look at. And Jen will kick us off with that now.
Yeah, so we've identified 4 main sort of sets of topics really that we thought we'd discuss with you that are being pursued by our committee, among some others as well in this project. And starting off with the definition itself. So as a whole, as a group of working groups, we all have to come up with this proposed consensus definition of death. And from our side as ethics and law, our contribution is to think a little bit about the significance of that definition ethically and legally, and the challenges, the legal challenges of that drafting. So starting with understanding the importance of the definition, because the definition will apply beyond the biomedical context. One can't have I suppose one could, but it's unlikely that we would have different definitions of death coexisting for different purposes. Something so fundamental is likely going to have to be agreed upon as one basic definition. And the definition is intensely important because it marks the moment legally where personhood ceases, legal personhood ceases, and human rights cease to exist. Although there are some continuing interests in one's will and so forth, the really important sets of personhood rights will end at this point. And the McKitty versus Hyanni trial level decision was a really good example of this, because one of the arguments that was made when the McKitty family challenged brain death was, well, there's no violation of your rights right now because you're dead, and dead people don't have rights. So you can see already the problem with that, because it begs the question, and it foreshortens the whole discussion or heads it off or stops it in its place. But it does show, if there's no charter rights for someone who's dead, it's pretty significant. What the definition of death is pretty significant. So in addition, there will be presumably no claim to continued medical care once you're dead, although of course it's not clear there's a continued right to futile medical care, even if you're not brain dead, but it will certainly be the case that there's no claim to continued medical care. It's important to the family as well. Many cultural and religious practices hinge upon the distinction between death and life. Grieving, of course, is affected by this definition. And then a whole host of other legal contexts, not just end-of-life medical care and whether you're a rights holder and a legal person and things like that, but criminal law will be affected. The timing of death and the cause of death can sometimes be affected by the way we define death, and testamentary dispositions as well, wills, estates, and the property aspects as well. So over to you, Christy, to talk about pluralism and diversity.
Sure. And I think, as I've already kind of highlighted, there is this sort of grouping around pluralism and diversity from both the ethics and the legal perspectives in terms of the two ways we can start to think about groupings of work that we might be looking at. And one is really thinking about it from that perspective of what are someone's human rights? And what about reasonable accommodation of minority views, right? If we put it in that more formal sense, it becomes this question of how do we demonstrate respect for that pluralism, for that understanding that a definition of death that is very biomedical, very clinically based, is not necessarily going to be something that all will ascribe to. So how do we begin to think about that and anticipate how do we have conversations when we know they might be challenging around understandings of death, approaches to it, and those kinds of impacts? So very much a legal aspect from a charter perspective, for example, but also I think then for me, really leading to that question of how do we engage well with each other when we know it's going to be hard, right? When there are going to be different points of view that are coming to the table, and how can we help prepare clinicians for that and even help prepare the public for starting to think about that as well. And then there is also this other piece that Jen had highlighted early on too with the legal context, which is around what is the impact of a consensus medical guideline? Which approach will work best? What's the thing that should be happening when we know some provinces have a definition that's already in legislation, other provinces don't, or not in the same kind of way that it's about accepted medical practice? And as Jen highlighted really earlier on in the presentation about, well, what about a federal level? What about a provincial approach? What makes the most sense? And certainly in some other conversation, there's been a question of, would it be appropriate to go to the colleges of physicians and surgeons to think about, would it be helpful if it's under accepted medical practices for the colleges then to be saying, here's what we understand it to be. And so working with the pros and cons and thinking through some of these aspects are a relevant way to help advance the conversation around what are we meaning by death in this particular context and what does it look like, while not taking on the broader claim of we're going to figure all of that out or advance all of that work and come out with a new legislation, for example, but really helping to lay out that groundwork around what might be the most appropriate way, what might be reasonable to think about from both a legal and ethical perspective. Back to you, Jen.
Okay. And the last two topics we thought we'd mention before turning over to discussion and questions with all of you is another thing that we're going to have to think about is what should the content of the definition be? And here's where we get into all these issues about how to precisely enough define the concept so that there's not going to be a lot of disputes about its meaning and whether certain situations fit within the definition or not. And so this is a matter of getting as clear as possible in the drafting. And I already mentioned the problem of there being a mismatch between the available tests and the definition. Does that suggest that the definition should be more carefully tailored to the tests that are available? Or is that kind of tail wagging the dog? But some of the definitional problems here are, I mentioned, what is a function? We have to understand what that is, because we are going to learn more about the brain and learn more about pockets of preserved activity And we need to know whether those are going to be construed as functions or not, that will affect whether someone's dead or not. Another word which has caused a lot of grief in the American definitions has been this idea of irreversible cessation. What is irreversible? Does it mean it is medically impossible to reverse it? Or does it mean it's medically possible but legally impossible? For example, if there's a do not resuscitate order in place. Or does it mean it's medically possible and legally possible, but someone has decided we're not going to resuscitate? Does that count as irreversible? And as we develop more and more forms of resuscitation and functional supports for failed organ systems, we are going to have this question more and more, because we have the ability to reverse, on at least some interpretations of that word, some of this functional loss. So we have to figure out what this irreversible is going to mean. And also another aspect, carrying on from what I've just said, is this idea of trying to future-proof the definition. So we need to the extent we can, like nobody has the necessary legislative crystal ball, but is there a way to write a definition where we have been clear enough about the underlying concepts that changes in the information and technologies and our abilities, technological capacities, won't upset too much the conceptual clarity that has been achieved. So for example, we might, as I say, be able to resuscitate organs, but another thing is we might actually learn more about ongoing pieces of function. I was thinking also about the research a few years ago out of the CESTAN lab of being able to resuscitate populations of neurons in decapitated pigs. So we can get a little Black Mirror and science fiction, but it would be advisable probably to think about what are the plausible directions of technological and scientific evolution, and as much as possible, take that into consideration in the drafting of the definition. Christy, over to you.
Okay. Thanks. Yeah, and just to sort of wrap up what we're going to be sharing with you today, and again, looking forward to your questions and comments, is really a lot of what I've alluded to and mentioned already, which is around how do we bring together sort of best practices and approaches for those disagreements or disputes when they arise, right? Figuring out the aspects around consent and whether it's required for testing, and if so, what testing. All of those aspects will be really helpful, because that then provides you with a pathway for thinking through that aspect of a dispute or a disagreement. But also recognizing that broader context around what do people understand we're saying from a medical perspective when we're talking about death or determining death, or what a death definition is. How do we talk about that in a way that makes sense, that doesn't use all of the really technical medical terms in a way that isn't able to be shared in a way that's understandable, right? Sort of how do we meet each other in that understanding of what we're trying to communicate, even if we disagree about what we're talking about. And so wanting to look at that really closely. And I think a piece of that we haven't quite touched on yet is to be thinking about this. And as we're looking at it, both from the definition and determination of death itself, but also thinking about organ donation, we are mindful that this is in the context of neonatal, pediatric, and adult settings. So the project is looking at that, and all the groups are thinking about this from those different practice contexts. And so I think for myself, as I reflect on some of ethics consultations that have arisen at the end of life, sometimes where questions of organ donation arise, how intimately connected questions are of, am I being a good spouse or partner? Am I being a good parent? To contemplate not only maybe accepting that somebody has died and trusting my healthcare providers when they tell me my loved one has died, but also then to go, am I comfortable saying yes to organ donation? Or what, knowing things have changed in our country too around that from a presumed or deemed consent perspective, needing to think about those aspects. But fundamentally, also wanting to go, are there relevant considerations in a neonatal or pediatric or adult context that we want to highlight and talk about? That might be, how much room do we allow people, space to accommodate in a different way, which is time to adjust to the fact that somebody has died. And how do we think about that in the context of everything that we're talking about too? And so wanting to be mindful of that aspect as part of how we think about responses to disputes. So with all of that being said from both of us, we'll open it up to you. We're looking forward to your comments and questions.
Thank you so much, Christy and Jennifer, for the wonderful and thought-provoking presentation. So for those of you who are logged into YouTube, you'll probably already know that you can insert your comments or questions there. If you're not logged into YouTube, however, or if you would rather submit an anonymous question, you can do so by emailing Lori Bulchak, and her email address is in the YouTube chat. And so the first question that I have on my list, and I can't see the YouTube list, so I'm seeing an anonymous question, which says, it's interesting to learn that medical tests cannot actually determine or establish loss of all brain function. Given that the loss of brain function is often used to describe brain death to families and the public, how do you think that this may influence public trust? It seems possible that the public may be immediately distrustful of any new definitions and descriptions of death if past descriptions were inaccurate and perhaps false.
I guess that's an interesting question, and a very interesting question and interesting concern. I guess I'd quibble a little bit. I'm not sure. I didn't mean to say that existing tests cannot determine brain death. What I was trying to point out is that the wording of the legal definition is something that there may be a bit of space between that legal definition and what the tests will do. So the tests will determine the loss of all sorts of all brainstem reflexes, for example. And they'll, and the question is that equivalent to the loss of all brain function or not? So the tests themselves are good and can certainly figure out what it is they purport to be figuring out. The question is, does that match up with the legally specified definition of death? And that's the little gap. So I wouldn't say that the tests are unreliable or improperly used or inappropriate, but that we have to make sure that they are matched to the definition itself.
Yeah, and I think the piece that I would pick up on too around that question of will people not trust the new definition, you know, kind of a new definition or something like that, really speaks to that piece of how do we talk about this? How do we frame what's going on? Because I think for me, it's a refining and evolution of the definitions as we learn more about how the brain functions and the type of tests that we can do to demonstrate whether those functions are happening or not. So putting it out as a, hey, we've got a whole new different definition is going to be problematic in a way that kind of goes recognizing the advances in our medical technology and the types of testing we can do. We want to be really clear about when we're diagnosing somebody has died, right? Or declaring that somebody is dead and on what basis. And so this is actually hopefully a way to gain further trust by being really clear about it and clearing up some of the confusion I think that has evolved over time as that question of consensus has started to move a little bit about accepted medical practices as well. So yeah, it's a great question for thinking through how do we talk about this and how do we set it up just in the way that Jen was talking about and sort of more generally as well.
Thank you. Okay. And I see that there was a congratulatory comment from Matthew Weiss saying, looking forward to this. Good luck, Jennifer and Christy. So I suppose Matthew posted that in advance of the presentation, which is lovely. The next question comes from Tim Mount Pleasant, who says, do you see that there is a challenge in the thought of a human rights case requiring someone to be defined as a person to make the claim? And if the person is declared dead, who would apply? So I guess, yeah, if you need clarification, just let me know. We can post that as well on YouTube.
Yeah. Just to make sure I understood the question, I think the question was, is there a problem here for these kinds of challenges to brain death if we say a dead person has no standing, and who will bring the claim? I think that have I understood the question correctly? Yeah.
That's my interpretation as well,
okay.
Yes.
So I think there's a logical problem if basically if we were to say that a dead person can bring no challenge to the definition of death, you've essentially made that particular definition immune from the Charter, because I don't think you would be able to have someone bring it on behalf of a dead person, because you're still talking about the rights of the dead person, and there is no such thing. So now what is good is that the Court of Appeal saw that this was a sort of a bit of a flaw in the at the trial level analysis, and said, okay, we're just going to assume she's alive, and we're going to do the analysis on the basis that there is a right at issue here, which I think was the right way to do it. I don't think it was satisfying, sort of intellectually satisfying to not inquire into it on that basis. But yeah, I don't see there as being an ability for someone else to bring that claim on behalf of someone who's dead, because it would have to be the assertion that the dead person has rights. So yeah. But anyway, it turns out that we have had a Court of Appeal decision go past that point. Yeah.
Thank you. Okay, a question came in from Neil Lazar saying that diagnosing brain death is important to discontinue machines and medications supporting cardiorespiratory function before or after organ donation without conflict. Could conflict resolution about brain death look differently depending on whether organ donation is proceeding or not? If you'd like me to repeat the question, please let me know.
Mm-hmm.
Yeah, just the last part, because I think I got it, but yeah.
Sure, yeah, so the last bit is, could conflict resolution about brain death look differently depending on whether organ donation is proceeding or not?
Yeah, no, I think to me, it's a really interesting question, because most of me says no. It's probably going to be similar in the sense of, if there's a dispute about whether somebody is actually dead or not, or a dispute about brain death, what happens afterwards? We kind of need to address that first before determining what's going to happen next. So I think it's more being mindful. There might be particular aspects that are being raised or that are maybe brought into the conversation or dispute. If you're thinking about organ donation, whether that's on the family side or whether that's on the healthcare provider side. So it may be a contextual feature, but I certainly wouldn't want it to be suggested that what's driving the focus of the conversation and kind of a sense of pressure maybe on the family to accept death is because it's about organ donation, right? We want to be clear that this is two different types of things that we're talking about, even though they're interconnected. So wanting to carve out that space and be clear around, let's talk about the death piece, let's look at the determination for that. And then if and when we know somebody is dead, then that's where the question about organ donation may arise. And there may be other disputes or questions that are very specific to organ donation itself that may have nothing to do with the question of whether somebody is brain dead or not, and the family accepts that, right, or has met that definition of death. So I think, yeah, it's a helpful question. We'll sort of keep track of that one to be thinking through, but that would be my first pass at it.
Wonderful, thank you. Okay, the next question, and there are a nice little list of questions coming in. So next one is from Tim as well, saying, just given Ontario's provincial strategy on the patient first idea, and so I think that this strategy is probably applicable in different ways to different provinces. That's me saying this. Do you think that federal or provincial legislation can address the different positions of this within the context of the individual?
I confess I'm not, perhaps I don't know enough about the patient first strategy or concept. So I'm reading into what that might be, which is sort of the patient-centered approach that we go with, the individual patient's views and autonomy and reference points. And I think a concept like that would suggest we should be, I guess, more accepting of a pluralism of diversity or minority viewpoints on this question. And there are some jurisdictions where there are forms of accommodation made available most extreme, I believe, is in New Jersey, I think, if I'm not mistaken, Christy, where a religious objection can be taken to brain death, and that's the end of the discussion. Others will allow sort of a 24 or 48 hour delay before removal of ventilation, for example. So it's an accommodation, just a little bit of time instead, which I think some families might say is no accommodation, but that is the accommodation that's made. So I suppose that the difficulties here are what to do in the context where, lurking in the background, there's this question of access to resources as well, that resources are not available to provide timely care to all sorts of people. Do we want, in a publicly or a privately funded system, to be devoting societal healthcare resources to the maintenance of people who are brain dead or severely brain injured, if you dispute the concept? So that's the central problem, really, is the conflict between sort of individual and group rights there. I wonder myself, and here I'm stepping outside the project, about whether there's other ways to get at this problem of, and this is I'm not inventing this myself. The idea has been suggested that where someone's brain dead, rather than forcing the issue, it is to not basically say there shall be no escalation of treatment, and that eventually someone who's brain dead would deteriorate to satisfy cardiorespiratory criteria as well. I guess another question which occurs to me is, beyond non-escalation of treatment, could one just not renew treatment on the theory that it's futile? So not argue whether someone's dead or not, but say we're not providing medically futile treatment. Now, in a way, this converts the dispute into a dispute over the meaning of futility, of course, but it is not requiring agreement on the metaphysical position about what is death. So I think this is where perhaps stakeholder discussions and sort of discussion with religious leaders and so forth would be useful. Is it more, as a matter of human dispute resolution, is it more likely to be better to go with one of these other strategies than to force people to agree on metaphysical points that don't have an absolutely correct answer?
Wonderful. Okay, so the next question actually is, I think, a really nice question based on what you were just speaking about, Jennifer, which is from Lana Elliott, who says that historically, determination of brain death has been associated with organ procurement. How have resources been considered as we look at scarcity during the pandemic?
Yeah, I'm perhaps not quite the right person to talk about this. I'm not right at the coalface in terms of trying to make those tough resource allocation decisions that healthcare providers have to make. But I mean, it is a question. If you have, for example, someone in an ICU on a ventilator who is brain dead, do you maintain those resources to sustain that brain dead person in order to then procure organs for transplant? When you have someone outside who has serious COVID and also needs the ventilator, and you could save 5 people over here, and it's a terrible trolley problem. And so I'm aware that these kinds of discussions are being had. I don't know if we've been ever in Ontario at a state where that decision we've been forced to make that decision. I think you and Christy and Andrea would know that better than me, so I'll shut up. Yeah, sorry.
Yeah, no.
Yeah,
no, I was just going to say what you were saying, Jennifer, is is akin to where my head goes with this type of question too, about the use of resources and allocation. And I think the pandemic really heightened attention to the ways in which we use particular kinds of resources like critical care, and knowing that fundamentally connects to things like organ donation. But for me, part of the connection between the previous question and this one is also that broader sort of ongoing tension that I think we have any time when we're talking about publicly funded healthcare, which is what's at sort of the broader public level about where they want resources allocated, or we want resources allocated, generally speaking, what happens within the healthcare system itself and within each province and territory about how they're spending those resources or allocating those resources. And then on an individual level, when you're the one that's most affected about having access or not having access to something, what does that actually mean? And so I think for me, again, it's both that part about how do we wrestle with the best of what we mean with things like patient first and patient and family-centered care, which is a call to how have we set up healthcare in ways that marginalize folks or exclude some folks and make access easier for others to those resources, while not also saying patient first means you get everything you want or need or desire within a healthcare system too, because we have to make those balancing acts in different places. And I think this one, just in the way that you were outlining, Jennifer, earlier about there's different approaches that we could be taking to handle some of the disputes, also have really interesting resource implications as well that are really great to be thinking through around, is this a better way to group some of the particular value considerations together and address those in a way that says, yes, that's where we want to put our resources, meaning not just the types of care, but also our resources in terms of our emotional energy and our types of discussion that we're having and those things as well. So both of these questions are really encouraging me to think more about all the different ways that we can think about strategies for handling and responding to disputes of different kinds that are all interconnected here.
Thank you. And perhaps, well, being mindful of the time, maybe we can squeeze in one more question if you're both okay with it.
Sure.
Okay. Yeah. So this question comes from Nicholas Murphy, who says, if the aim is to offer a biomedical view of death, as opposed to a metaphysical view, will the clarification or potential legislative harmonization sought by the DDD project do anything to forestall challenges to neurological death determination on, for example, religious grounds?
Probably not. I think it would not solve that basic metaphysical problem. What it would do is, if it's legislated, what it would do is constitute a democratically accountable definition. It would be a statement by sort of the body that can create valid law of what the law is going to be in the country. So it wouldn't solve the dispute, but it would change the particular way that it gets resolved. It would be a government act. It would then be clearly subject to charter evaluation, and that would look at this question of pluralism and of minority dissidence from the majority's choice. So we have a way to resolve these kinds of conflicts, and by legislating, we would clearly put it in that domain.
Wonderful. Okay, and we'll make sure, Christy and Jennifer, that you do get access to all of the comments and questions that were in the chat. But for now, unfortunately, it is time to draw today's seminar to a close. So I have a couple of very brief announcements to make before we thank our speakers. Our next seminar will be on Wednesday, March 24th, where Sarah Kawaguchi and Bill Ma will be discussing clinical complexity in medical assistance in dying, a psychiatric and palliative care perspective. And for those of you who are interested to sign up to receive our weekly seminar reminder emails, please email jcb.info@utoronto.ca. And CSB students enrolled in the student seminar course, please remember to keep track of your attendance. Jennifer and Christy, on behalf of all of us, thank you so much for your thought-provoking and informative presentation. We appreciate it.
Thanks for having us.
Most welcome. Thank you.